Morning, everybody. Thank you all for joining us. We're just going to wait another second or two here before everyone gets in from the waiting room, and I think that's it. All right, well, Happy New Year. This is our first time together in 2026. It's been a few weeks because we had 2 weeks off at the end of last year. I hope that all of you had, if not a break, I hope you all had a break. But even if you didn't have a break, I hope you had time to just enjoy a little bit of time with loved ones or get away from the daily grind even for a couple of days. But we're glad to have you back with us. And I'm going to go ahead and jump right in with our Zoom housekeeping tips like I usually do and start by asking everybody to stay muted unless you would like to unmute yourself to ask a question. It just helps cut down on background noise. Your Zoom toolbar is probably at the bottom of your screen, depending on what kind of device you're using, and that's where you will find your audio and video buttons. So if you want to unmute to ask a question, that's how you do it. If you want to put your video on or off, whatever your preference is, that's also how you do that. And there's also a chat button, which might be flashing right now because I just put a message into the chat. The chat is a great way for you to ask questions if you want us to cover a particular topic today. We do have a good number of questions that were submitted in advance, but we might have time to get to a couple from the chat. The chat is not intended for, intense discussion or commentary of a legal nature, so keep that in mind. Please also keep in mind that nothing in the chat and nothing that we say here is legal advice. We are here to give general information only, not to give legal advice. You can only get legal advice from your association attorney in the appropriate setting, which is not this. So sometimes we have questions that come in that are way too specific. If they are on a topic that we think is broadly helpful to people, we will try to simplify the questions and de-specify the questions so that we can still cover the topic without getting into really specific territory that would be legal advice. Other times we just have to tell Chelsea to email folks back and say that's too specific and we can't cover it. Again, don't shoot the messenger. She's not the one that makes those judgment calls. That's us. So if you want to be mad at anybody, you can be mad at me. But we don't do legal advice here, so just keep that in mind. That does mean that if somebody sends you one of our video links or a blog article from us or any other law firm even for that matter and says, you have to do this thing or you can't do that thing because of something that Valerie said or Lisa said or Ken said, whoever, you can ignore that because this is not legal advice. That being said, we do think that having an ongoing relationship with an association attorney is a really beneficial thing for every community, even if you have not ever needed legal advice up to this point in your community's history. As is evidenced by a lot of the topics that we cover in these Q&As, the legal landscape in Washington State is shifting pretty rapidly and pretty frequently. And I have no reason to think that that's going to change anytime in the near future. So if you don't already have an association attorney, you should probably work on getting one before you're in a crisis mode and feeling pressured to do that under worse circumstances. So that's all I've got on that topic. I want to remind everybody that just because we're back for 1 week here does not mean, I guess, we're doing every week. We're all gone next week for the National Law Seminar in San Diego, CAI's National Law Seminar. And so we are not going to have our Zoom Q&A next Wednesday on January 14th. So once we come back from that, I think we're kind of going to level out onto a little bit more normal schedule, but we're just here for the 1 week only, and then we are off again next week. Please keep that in mind when you're looking at your schedule next week. We've been reminding folks or sort of warning folks for a while now about some legislative changes that took effect on January 1st of 2026. So we're not here anymore to talk about what is an upcoming change. This is now in force and effect for all community associations in Washington State. And the two big changes on January 1st of this year are that all communities in Washington State are now subject to the WUCIOA meetings provision. And you can just Google RCW 6490 meetings. I think it's 445, I think is the subsection. And the big changes there for communities that have not been subject to WUCIOA or the HOA Act, as a different example, is that all board meetings are now required to be open. You have to give notice to your owners, a minimum of 14 days notice, unless there is an emergency and there's a specific section in the statute that deals with how you give notice of that kind of board meeting. Open board meetings are now required for all communities in Washington state. You have to give a minimum of 14 days notice to your owners. You have to send out the agenda 14 days in advance of the board meeting unless you have published your annual board meeting schedule in advance with a general agenda. In that case, you don't have to then also send the specific agenda of each meeting. And there is a limitation on making substantive board decisions outside of board meetings. So boards are no longer allowed to vote via email to make substantive board decisions. The statute allows only what are called ministerial decisions. And of course, in a stroke of genius, the legislature failed to identify or to define what ministerial actions include. So we're left to look at kind of the dictionary and the common understanding of that word, which I think essentially is more or less this. If the decision is a new one that the board has not already discussed and made a decision on in the past, and it's a decision of substance, then it needs to be made in an open board meeting. If it's a ministerial decision, meaning you're rubber stamping a decision the board has made in the past, or the board made a decision sort of setting certain parameters for a thing, and then you're kind of rubber stamping that by finalizing a decision, those kinds of decisions are likely ministerial and can be made outside of a board meeting. We do have some clients that are also adopting really detailed policies and delegating authority for certain things, either to their manager or to an individual board member. You'll want to consult with your association attorney to determine what kinds of decisions are appropriate for that kind of delegation and whether that turns something into a ministerial decision. But really the bottom line for everybody to understand is every community association in Washington is now required to hold open board meetings. You have to give 14 days notice of those meetings, and any substantive decision that the board is making has to be made in a meeting. So if you're a community that's been functioning with quarterly or twice a year board meetings and just making all your decisions by email in between, you are no longer going to be able to function that way without being in violation of the statute. So the recommendations that we're making to all of our clients and our community as a whole is just hold more frequent board meetings. Eventually, you will get really efficient at them. Sometimes you might even be able to cancel them because you don't end up having any business to do at your newly scheduled monthly board meetings. If, for example, you've been operating on a quarterly board meeting schedule before that, and limit the decisions that you make by email to things that are really just sort of like administrative and inconsequential in nature. The other big legislative change that took effect on January 1st is the new delinquency notice requirements, which require that a certain specific notice be mailed to your owner, to a delinquent owner, within no more than 30 days of an unpaid assessment. So it's not within 30 days of when the assessment becomes late, it's within 30 days of when the assessment was due. So if you're a monthly or quarterly or even annual dues kind of association and there was a charge due on the 1st of January, even if your grace period and your late fee don't happen until the 15th of the month, that assessment is due on the 1st of the month. Within 30 days, you have to send a delinquency notice that complies with the statute. If you look at our Zooms from early December, we went in detail through what the notice has to contain. And until 15 days after you mail a notice that complies with the statute, you are limited to charging one late fee of no more than $25, or actually, is it $50 or $25? 50, sorry. Or 5% of the unpaid assessment, whichever is less. So for a lot of communities, the actual amount is going to be way less than $50. You're allowed to charge one admin fee of no more than $10 for sending the delinquency notice, and you can charge the cost of postage and mailing to the delinquent owner. Until 15 days after you mail the notice, you can't do anything else. You can't charge additional late fees. You can't record a lien. You can't refer an account to your association attorney and collect the legal fees from the unit owner. So sending a delinquency notice that complies with the statutory requirements is going to become very important in allowing you to move your delinquency process forward once an owner falls behind from January 1st, 2026 forward. The last thing that I wanted to cover briefly before we jump into the questions is a topic that Ken and Lisa and I were chatting about this morning, which is we want to make it clear to communities that are looking at the open meeting requirements of the statutes now. And we want to make it clear that the open meetings provisions do not or not are not intended to override attorney-client privilege. So if you have a community that is in litigation, we want to make sure that you're careful and that you don't damage or waive attorney-client privilege in your efforts to comply with the transparency requirements of RCW 6490-445. And what this means is this. If you are in the middle of a construction defect case, if you're in the middle of some other litigation dispute with a homeowner, and your attorney sends you a litigation report, they send you a monthly update memo that has details about the foreclosure litigation with a unit owner. Number one, those topics are specifically provided for and can be covered in executive session rather than an open meeting, so that you're not disclosing attorney-client protected information in your board meeting. And number two, those privileged communications, which most of the time we mark those, like our monthly update memos say in bold, red, caps lock type, attorney-client privilege, do not disclose. Communications like that are part of the board packet for the board meeting should be withheld or redacted from the version of the board packet that's made available to owners to comply with the statute. So this is not by way of trying to hide things from your homeowners. You can talk generally about what litigation the association is engaged in the open board meeting. But when you're actually discussing attorney-client privileged communications, requests for decisions, things like that, those discussions should happen in executive session. And then you come back to your open session to make motions and record those in the minutes. So again, there is transparency there, but we're just trying to balance that transparency against the very, very important consideration of protecting attorney-client privilege. So that's all that I have as far as general topics and announcements. And I think, Lisa, unless you want to comment on any of that, you can go ahead and jump us into the first question.
Yeah, I think the only thing I would comment on the attorney-client privileged comments you're making is if you have questions about it, talk to the counsel that you have retained for whatever the litigation is and see what you're able to share and what you're not able to share, to make sure that you don't lose that privilege. So if you have questions, definitely talk to your attorney prior to saying anything in an open board meeting about litigation. Okay, the first question we have is, we recently elected a new board of directors and none of the board members wants to be vice president. They did elect a president. Is a vice president required? If no one agrees to be a VP, what are our options? And the short answer to this is a VP is not required. Even if your bylaws say that there's an officer role of vice president, you can leave that position vacant. I don't know what statute your community association is organized under, but generally speaking, the statutes are silent on specific officer roles and what requirements are there. You can look at 649410, which says, unless the declaration provides for the election of officers by the unit owners, the board must elect the officers. That's basically what it says. The Nonprofit Corporations Act does say there needs to be a president, a secretary, and a treasurer. So I think if you've got those three roles filled, that should be sufficient. Other officers could be authorized by your bylaws and other articles of declaration and things like that. But if it's not in there, or if you are not able to find someone who's willing to serve that role that is not critical to the functioning of your board, you can certainly look at your bylaws for more information on what roles and what requirements people are required to fill. But if you, for example, you're just able to get people to agree to be those three roles, I think you're probably in good shape. I think that's it. That's a pretty short and sweet. Anything to add to that one, Valerie?
Well, the one thing that I'll add is what we talked about briefly with Ken, which is that we do think a lot of people afford more weight to the officer role than we think is warranted from a legal perspective. Just because somebody is the president or the secretary or the vice president does not mean that they have any special authority other than, for example, the president to run the meeting, for example. But board members' authority comes from their participation and their action as a whole board, not from their officer role. So I think it was a helpful conversation that we were having about the distinction between board authority and the officer role, which is what each of those things talks about. So the president has the role or the duty of running the meeting, and the secretary has the duty of keeping the records, and the treasurer has the duty of overseeing the finances, right? But that does not mean, for example, that the treasurer has the right to make all financial decisions on behalf of the association, or that the secretary gets to destroy association records without a vote of the board. So there's a difference between somebody's role or duty as an officer and between their authority as a board member. And sometimes understanding or sort of emphasizing that distinction can help illustrate why it's unimportant or not really a big deal, for example, that your vice president officer role might not be filled.
I think that's right. A lot of folks tend to say, the president said we can't do this, or the president does X, Y, or Z. The president is also just a member of the board. And again, as Valerie said, is really charged with running the meetings, for lack of a better description. So make sure that you're not affording folks more power than they really have.
Yeah. All right. Next question here is a multi-parter, and it's about association votes at association meetings. So I'm going to just read all the questions and then run you through our commentary. For any meeting where owner votes are taken, does CLG recommend counting ballots during the meeting? Is having the property management company count the ballots off-site without board or owner oversight something CLG would generally approve? Does CLG recommend issuing the results in writing to the owners with all of the names of those voted for and the counts for and against? And does CLG have any HOAs that do this? So I think we have to start by saying this is very, very specific. But there are things that we would think about when we were advising a client on questions like this. So typically when we attend a meeting, for example, where there's an election happening or a vote on an amendment or some other association-wide decision like that, we would typically count and announce the results at the same meeting if the voting is being done at the meeting. So if the voting is happening in real time as opposed to, mail-in ballots, we think counting and announcing the results at the meeting is sort of the default. For WUCIOA communities, it's important to keep in mind that some votes must be done by secret or confidential ballot. So you would never disclose how any particular member voted. But this particular section, which is RCW 6490-455, does not yet apply to all associations, but it will in 2028. Absentee ballots prepared by the association can be counted towards the quorum for a meeting. And so that might be something that you have to consider in figuring out when and how to count ballots. And part of the question that I would also have to ask a client that was coming to me with questions like this is, are you using electronic balloting? And what is the process that's supported by the platform that you're using? If you're expecting a contentious vote, I think one option is to have your attorney attend the meeting or a parliamentarian who can be an impartial third party to count the votes. But I'm also going to play devil's advocate or present the opposing viewpoint here, which is a lot of owners, if the association's board hires an attorney and has that attorney come to the meeting thinking, oh, they're going to be viewed as an impartial third party and the owners will trust the vote outcome if the attorney counts it. There have been meetings where owners do not trust the attorney because they basically think that we're sort of in the pocket of the board and we're just doing the board's bidding. But this sort of illustrates a larger issue that we see, which is that there's a lot of owner suspicion that boards or managers are out there like fudging votes to like throw an election or, sway the outcome of a result. And I'm not going to pretend that that has literally never in the history of ever happened in a community association. But I can tell you that I've been practicing in this practice area for 18 years. And I have never once in my personal experience seen evidence of a board or a manager mucking with the ballots or intentionally misleading or miscounting to sway or change the outcome of an election. So that does not mean it never happens, but I think it's safe to say that it is pretty rare. I don't think that we recommend sending out specific results to all the owners, meaning these people voted this way on this issue and whatever, but the outcome of the vote should certainly be provided to the owners at the meeting. You could certainly then also send out a mailing, and most of our community clients do send out a mailing after, for example, an election or a vote on an amendment to notify the ownership of what the outcome of the vote is. Our governing statutes for all communities in Washington do allow for voting outside of meetings, which would support counting or collecting ballots by email or electronically. And results of votes that are done by mail or electronically do have to be announced formally to the community, but that may not happen at the meeting itself, right? Depending on what deadline you gave folks for those absentee ballots. Stepping back a little bit from all of these specifics, I think what we are supportive of is a voting method or methods that encourage owner participation and that make it easy for owners to vote. And we generally have no reason, like I said earlier, to question ballots that are counted by managers. And I think part of what I think we see folks assume is that, well, once the votes are counted, that's the last time anybody can look at them, and like, how do we know that it was done correctly? Well, you know, because you can audit the results after the fact if necessary. In addition to that, and again, this is specifically WUCIOA, so this does not apply to everybody yet, but it will in a couple of years. WUCIOA provides some really specific assurances that votes are fair and accurate, including that when unit owners vote by absentee ballot, the association has to be able to verify that the ballot was cast by the unit owner that has the right to cast that ballot. And when a unit owner votes by proxy, the association has to implement reasonable measures to verify the identity of the unit owner and the proxy holder. And WUCIOA also says that the association shall implement reasonable measures to verify that each ballot in a tangible medium, meaning every written ballot, and electronic ballot is cast by the person who has the right to cast the ballot. So at least under WUCIOA, the association does have a duty to take steps to verify that the people who are voting are the ones who should be voting. So hopefully that at least gives you some of the considerations that we would work our way through when we're advising a client on questions like this. Without getting too specific, I'm not sure that there's a whole lot more than we can say, but Lisa, if you have anything to add, please feel free.
Nope, I don't think so. I'll just go on to the next question. My board, of which I am secretary, needs to undo a previous board's resolution, which was not voted in by the owners and has tenuous legal standing. Do we pass a resolution to eliminate the previous one? We are presently organized under 6432, so the old act, condominium. I'll start out by saying we just don't have enough information here to provide an answer to this. And also, I think we're veering pretty close to legal advice when we are talking about it. And we're also don't actually know what you're talking about specifically when you say resolution. There, a resolution could be just that, a resolution of the board. We say we're doing this, or you might mean something different. So I just want to be careful with how to say that I'm not entirely certain exactly what type of thing you're talking about. If this is simply an action by the board that was documented in the meeting minutes, I think that that's different than some policy or something like an amendment or a restatement or something recorded with the county, for example, and noticed to everyone. But if it was something that was done at a board meeting, a resolution of the board, we are going to proceed this way on this type of thing, and then you realize, oops, that was wrong, we made a mistake. A motion on the record at a properly noticed board meeting with the agenda, as we talked about before, sent ahead of time to all the members, and a motion rescinding that resolution, if it is in fact just a resolution, is probably what all you need. Then you would have your new resolution noticed the same way as you were doing the undoing, recorded in your minutes, notice to members, motions on the record, things like that. Could be as simple as that. But there are some things that you can't undo. So for example, when you say a resolution, you're talking about a contract you entered into with someone to perform services for your community. That's a signed contract. That's not something you can just undo by a motion on the record at a board meeting, because that involves contract law, and that's something totally separate. So if you have specific questions about something that your board did or didn't do or did wrong, for sure talk to your legal counsel about that, because this is as I said, just a general response to what I'm thinking you mean when you say resolution, but you could have a different interpretation, or your board could have a different interpretation. So make sure you ask specific questions of your counsel if it's something more than that, or if you just have questions about that. Anything to add to that, Valerie?
Nope, I think you covered it. So I will move us on to the next question. With all the new changes, does the board's secretary need to record any and all comments of owners in the first 15 minutes of the board meeting? The board can electronically record the meeting for reference purposes and later delete said recording, right? So short answer to this question is I don't think you need to record any and all comments of your owners during the owner comment period, but I do think it would be appropriate to note the topics that were raised. So in your minutes section, you might just have a heading that says owner comment forum or owner forum, whatever. And then bullet points, like somebody asked about removing a tree. An owner provided feedback on the proposed change to the association rules. An owner asked questions about a line item in the budget. So I think you can have a very general listing of the subjects that were raised during the owner comment period. I do not think you need to record anything verbatim. I don't think you need to include a high degree of detail. I don't think you need to identify by name who said what. Keep in mind that the minutes are intended to be a summary of the motions and actions taken at the meeting. And I think a short summary of the topics covered is more than enough to include in the minutes when you're talking about the owner comment period. As far as what the meeting section says that your minutes have to cover, it's specifically in RCW 6494-45, subsection 4 says, minutes of all unit owner meetings and board meetings, excluding executive sessions, must be maintained in a record. The decision on each matter voted upon at a board meeting or unit owner meeting must be recorded in the minutes. So aside from that, which basically just says everything that you voted on has to be recorded in the minutes, nothing else is necessarily required. Now, some caveats, look at your governing documents, which occasionally have, rarely, but some commentary on what your minutes should look like. Sometimes your governing documents might even have like a template agenda or minutes that you could work from. You can also look at Robert's Rules of Order if your governing documents require you to comply with them, but I don't think that it's necessary. It's a good general guide, but it can often be more complicated than most communities need. But again, minutes are not intended to be a blow by blow. They're not intended to be a transcript. They're not intended to be 10 minutes or 10 pages long. They're intended to be like, the meeting was called to order at X time, but the board has a quorum. The owner comment period took place and these 3 subjects were raised, or nobody had anything to say during the owner comment period. And then, you move through your agenda items essentially and the motions that were made and the votes, the outcome of the votes for whatever actions are being taken at that board meeting. As far as the question of whether the board can record the board meetings, certainly there's no reason that you can't record a board meeting. We do think it's best practice to announce that it's being recorded at the beginning of the meeting so that it's not catching anybody unaware. I do think that depending on what the purpose of the recording is and how long you keep it, then there's the question of, does it become an association record? Most often, the way we see this used is that a board secretary will record the meeting so that they can go back and listen as they're preparing or finalizing the draft minutes to make sure that the minutes accurately reflect what was done at the board meeting. And if the recording is made for that purpose, kept until the minutes are drafted and then destroyed after that, I think that's not likely to be something that would be considered an association record because it's not being retained. But I think if it's being retained for any length of time or used for any other purpose, then it does likely become an association record. And then you've got, requirements around like disclosure, et cetera. Also, I think it's really important to point out that in particular, once the minutes are approved at the following month's board meeting, the minutes are the official record of what happened at that board meeting, regardless of what is contained in the recording. So having a recording, we think sometimes folks say, well, the recording controls. No, the minutes that are approved by the board at the subsequent meeting are the official record for the association of what happened at that meeting, what votes were taken, what actions were taken. And so the recording sort of becomes unimportant after the fact if it's being used for any purpose other than making sure that the secretary gets the minutes drafted accurately. I think that covers it. If you wanted to add anything, Lisa, please feel free.
I'll just say, as someone who reviews a bunch of minutes, starting with the agenda and literally just saying motion to X passed unanimously. Next issue, motion to, that's really all that is needed. As Valerie said, it's just the record of the actions taken. Sometimes you, as Valerie said, you get pages and pages and pages of conversations that you don't need to have. The mention that something was discussed is great, but keep it simple, I think is the.
I do want to add one other thing to piggyback onto that, which is the one exception to that, I think, is if you are relying on a certain pieces of documentation or information in order to support a certain decision, I think it's appropriate to say the board reviewed, the attorney's recommendation and the request from XYZ owner. The motion was made to do this thing. This, here's how the result of the vote was. Documenting in the minutes what evidence or information the board relied upon in making a certain decision is not inappropriate. And I also think wouldn't unnecessarily lengthen the minutes. I think for most decisions that's not necessary, because for most decisions you're not relying on a whole lot of extrinsic information or evidence, basically.
Okay. Next question. Are there any hints from the legislature that they are considering further updates to WUCIOA that will take place before 2028? And this is sort of one of those questions that I'll answer a little bit. Valerie's on the lack of the Legislative Action Committee, so she can answer a little bit more specifically. But as has happened every year, and since WUCIOA has been put into place, there have been tweaks to the statute, and there will continue to be tweaks to the statute. I think we can guarantee that. We can't always predict exactly what will be there, but as Valerie pointed out to me at the beginning of our conversation, things, because this is a biennium, things that were not passed last session may roll over into the new session, so they may be taken up again. The session is preparing to start on January 12th. And this is a plug, I think, right now. If you're interested in this kind of thing, sign up for the LAC's, is it the Monday Morning Minute, I think is what it's called. And if you just go on WSCAI's website, you should be able to find that. Just Google that. But I know that there are a couple things that I saw on the horizon when I looked at the legislature's page. There's a restriction proposed against associations to make things like restrictive covenants that were not in place when an owner bought a unit, not able to apply to that unit until it's sold. But we currently have that in case law. We've talked about that quite a bit extensively, some cases in Washington State. But I think it's just helpful to know that there is always going to be some folks who feel very strongly about things, who are going to propose changes or amendments on both sides of whatever situation or opinion you may hold, pro, con. And so things will be suggested. There may be some things that are tweaked and changed because things might not have been as intended by the legislature, I think. So I think every year until 2028 and then beyond 2028, we'll see some changes. Valerie, do you want to mention some specific things may be coming?
There's not, so the two things that I was thinking about before the meeting are actually not amendments to WUCIOA at all, but they are legislative potential bills that have the potential to impact community associations. One of them has to do with requiring HOAs to allow fire retardant or damage resistant building materials, which can have some interplay with architectural rules that certain communities enforce, pretty strictly because of wanting there to be visual uniformity within their particular community. What I was going to say more broadly is that WUCIOA was enacted in 2018. It was amended in 2019. It was amended in 2021. It was amended in 2023, 2024, 2025. So I think the chances that they will not amend WUCIOA in any given year are very slim. And we will do our best to keep you updated. I did put a link into the chat. If you click on that link, it will take you to the page where you can sign up to receive the Monday Morning Minute from the WSCAI Legislative Action Committee. Unfortunately, I'm not really sure why, but there are rules around all of this stuff. And so every year that email list gets purged. So you have to sign up again each year. So this is the Monday Morning Minute for 2026. We try to send out, we do send out an email every Monday during the legislative session. Sometimes it's a general update on what's going on, but other times it's a call to action where we're asking people to contact legislators to express a certain opinion on a proposed bill. Other times we're asking people to be willing to zoom into a hearing in the Capitol to testify on a particular piece of proposed legislation. And those requests in particular are critical because the legislators don't want to hear from the lawyers on the Legislative Action Committee. They are sick of hearing us talk, and they're hearing from unit owners that we're biased or that we that we are unfairly biased, I guess, in favor of community associations to the exclusion of being able to see an individual unit owner's position on something. And my opinions on that position notwithstanding, it is incredibly helpful when we can send a manager or an accountant or a homeowner or a board member to testify in front of the legislature, because number one, it's not a lawyer, and that you're already more credible to them just by virtue of that fact. And number two, you all are their constituents. So the Monday Morning Minute and your willingness to participate in the calls to action that we send out are really critical. So please consider signing up for that. Like I said, I put the link in the chat, and we'll try to remember to put that in the chat each week going forward. All right, next question. We are a small HOA with nominal reserve costs and a modest budget. As such, we feel we qualify to be exempt from a reserve study as provided for in RCW 6490-545 subsection 2. What language would be appropriate on the resale certificate in this situation? The sample language provided in 6490-640 subsections 1Y would not apply since we are not required to have a reserve study. So I'm going to disagree with the premise of your question. And I'm going to back up and say, here's the caveat. This is really specific. And if you want a legal opinion that shifts the risk of liability for any decisions that you make around this, you need to consult with your association attorney about this question. So this is more than just my standard disclaimer that we don't give legal advice. One of the reasons to get legal advice is because it shifts some of the liability risk from the association to the law firm if you make a decision that relies on that legal advice and then liability results from that decision. So that's the caveat here. So that being said, we do not believe that associations that are exempt from the reserve study requirements are also exempt, and I'm using that word, in quotes because it's not from the statute, from the requirement to disclose the lack of a reserve study on the resale certificate. In other words, the section of the statute that may exempt any given community from having a reserve study done does not also mean they don't have to disclose their lack of a reserve study on their resale certificate. So RCW 6490-640 subsection 1 contains a list of what is required in every resale certificate. And subsection 1Y reads exactly as follows. If the association does not have a reserve study that has been prepared in accordance with, and it gives the statutory citations, or its governing documents, the following disclosure, and this is what has to be included on the resale certificate. This association does not have a current reserve study. The lack of a current reserve study poses certain risks to you, the purchaser. Insufficient reserves may, under some circumstances, require you to pay on demand as a special assessment your share of common expenses for the cost of major maintenance, repair, or replacement of a common element. Nothing in the statute contains language that suggests that an association that is exempt from a reserve study can omit the required statement that I just read from your resale certificate. So I'm not sure why the board thinks this language doesn't apply. These are two completely different sections of WUCIOA. They only refer to each other in terms of whether the reserve study is prepared in accordance with the reserve study sections of WUCIOA. I would tell any client of mine, even if I gave them advice that said, yes, you are in fact exempt from the reserve study requirements of WUCIOA, I would still tell them that they had to put that statement on their resale certificate in order to comply with the resale certificate provision of WUCIOA. So, so that's why I disagree with the premise of your question. Just because you're exempt from the reserve study requirement, if you are, I'm not saying you are, but if you are, does not mean that you get to omit this statement from your resale certificate. Lisa, did you have anything you wanted to add?
Well, I think just the key is it doesn't mean that there isn't a risk still, right? So the fact that you're exempt from that reserve study does not mean that your association is exempt from a risk of needing a special assessment later or from something else. Just because you don't have to plan for it with a reserve study doesn't mean it might not happen. So that statement is very critical for a potential buyer to know. Do you have a reserve study or not? It gives them, it gives you some cover, and it gives them some confidence or information anyway before they purchase the property. Okay, next question. Is the board required? This is a two-parter, so I think I'll try and answer it in two parts, and so it doesn't get too confusing. But the first half is the board required to provide a board member or other person a form for an owner to use as a proxy? We've advised our owners to make their own arrangements to find a proxy to represent them. So the short answer is an association doesn't need to provide proxy forms, but if it is provided a proxy or that is prepared by an owner that meets statutory requirements, it does need to accept it from that owner. The statute doesn't say anything about who they need to use as a proxy. If you Google proxy and your statute, you'll find it. But if, for example, you can look at RCW 6490455, discusses all the rules and what is required to be in a proxy. The owner does need to designate someone, and that honestly could be anyone that they designate. Some boards, as you kind of allude to in your question, do provide proxy forms that maybe name a particular person as the proxy, a board member or someone else, but that is not set out in the statute. So if an owner says, I want my brother, I want my tenant, I want my wife, whoever it is, that is allowable under the statute. There could be, I suppose, in your governing documents, a restriction on this, but so check there first. I mean, as we always say, always read your documents before making any grand statements or anything. But generally speaking, the statute allows an owner to give a proxy to whomever they choose. The follow-up question that the person asked is it appropriate for a board member to solicit proxies or accept an owner's request for that board member to be an owner proxy with the intent of voting against a board decision, something that's coming up before the board? So, for example, reject the budget. This particular person said that they've asked the board members not to accept owner proxies. Again, the answer to this is nothing prohibits any board member or anybody else really from serving as a proxy for another owner. So I don't foresee any problem really with a board member soliciting votes, soliciting proxies from owners in advance of a meeting. If a board member wants to go door to door and ask folks to appoint them as the person to vote on a particular matter, or any other owner for that, if any other owner for that matter wanted to go door to door and solicit proxies, that is within their right. Anybody else could do it as well. If this is not to say that would happen for a board action. So a board member couldn't go to other board members and say, give me your proxy so I can vote on behalf of you for the board member. Board members need to vote on their own behalf. They cannot appoint proxies for board decisions. We're talking about a general owner meeting or owner vote. I think that's probably about it. I think, there isn't anything prohibiting that practice. I think use it, I don't think you should need to restrict board members from accepting or rejecting proxies by owners. I think honestly it could make it simpler. You have quorum at a meeting if someone solicited enough proxies. Boards and associations have such trouble getting quorum at unit owner meetings anyway. So the more interaction and more engagement you have is probably preferable. Valerie, anything you want to comment on that I may have missed?
No, I don't think so. I think, again, going back to the statement that I said in an earlier answer, we want to encourage practices that make it as easy as possible for unit owners to vote. And even a proxy does that, because if a unit owner is giving their proxy, either it's a directed proxy, in which case their actual vote is being counted, or they trust the person to whom they are giving the proxy enough to make a decision on their behalf. And I think communities should do what they can to facilitate those votes, provided the association is taking the steps that it needs to take to verify the proxies and other things that we've talked about before. The next question is a short and sweet and easy one, which we don't get too many of those. So here is the question. Does WUCIOA specify whether cash or accrual accounting is to be used for condo bookkeeping purposes? And the short answer to this question is yes. And the long answer is also short, which is RCW 6490-530, subsection 1 says, the association must prepare or cause to be prepared at least annually a financial statement of the association in accordance with accrual-based accounting purposes. I feel like I should say thank you for coming to my TED Talk or something, because that was really short and sweet, but there you go.
That's it. We all were very happy with having an actual answer. And I guess I'll plug on that one. Sometimes, and we've said it a bunch of times in our conversations, but you can put into your favorite search engine some of those words and your statute, and oftentimes it'll come right up. So that one was nice to have a quick one to answer. Okay, the next question is, as a condominium association, does Washington State require us to conduct a separate audit of the bookkeeping of our certified management company? And I guess I'll back up a little bit and say that Washington doesn't certify management companies. So it's an unregulated industry. It doesn't certify managers on a state level. And there's no certification process for a management company. So just to qualify that question with that comment. So I'll just read it as your management company, because there isn't a certification process. So I think what the person is asking is, does the statute require us to audit or to audit the bookkeeping of our management company's bookkeeping of our stuff? If the question to that, if that is the question, the answer to that is no, it doesn't. But if you're asking, does the statute require an association's records to be audited when they're handled by our management company? The answer is yes, they do. It does. You can look at, if you're a non-WUCIOA condominium, you can look at 6434-372, which says, at least annually, the association shall prepare or cause to be prepared a financial statement of the association in accordance with generally accepted accounting principles. It goes on and gives some qualifications onto size of community. WUCIOA has similar language that allows allows associations to avoid the audit if their budget is under a certain dollar amount, which is $50,000 instead of a unit number, which is in the Condominium Act. And then the HOA Act is 6438-045, which talks about 67% of folks at a meeting with a quorum can waive the audit, and we'll talk a little bit more about that later. But the shortest answer to your question is, the audit is required of the association records, not the management, the management records. No matter who does your books, the books are required to be audited with some caveats as to size or amount. Anything you want to add to that, Valerie?
Nope, I think you covered it. I'm just copying and pasting some things from our notes into the chat so people can see the specific provisions that you were referring to.
Okay.
All right, next question. If you have a quorum for your budget ratification meeting and meeting minutes were recorded, when would you typically get these meeting minutes approved? Would it be at the next monthly board meeting? This is a great question. And we actually covered this question, I don't know, 2 months ago in the Q&A. But your budget ratification meeting is essentially just an association meeting with a different name, right? Even if the only business you're doing is ratifying the budget, it's an association meeting. And so you would approve the minutes at the next association meeting. We have talked about in our Q&A before how to sort of provisionally approve, I guess, have the board provisionally approve annual meeting or association meeting minute drafts in between them. And part of why we've talked about this before is because under the HOA Act, for example, minutes from an association meeting have to be made available to the unit owners within 60 days of that meeting. But if your next association meeting isn't until a year after the last one, then what you're disclosing to the owners is a draft set of minutes. And so I think if that's the scenario that you're dealing with, one thing that you do is you clearly mark the minutes that are drafts as drafts until they're approved. So that even if, for example, a unit owner contacts you and says, can I please get a copy of the minutes from the association meeting that was 45 days ago, or 90 days ago, let's say, so we're after the 60-day mark. You do have to give them a copy of those draft minutes, even if they're not yet approved, but just make sure they're clearly marked as draft. You don't approve, again, minutes from each type of meeting are approved at the next meeting of that type. And your budget ratification meeting, even though you're calling it a budget ratification meeting, is also an association meeting. So let's say you have your budget ratification meeting in October, and then you have your association annual meeting in December. You can approve the minutes from the budget ratification meeting at the annual meeting in December, because that is also an association-wide meeting. You don't have to wait until the next budget ratification association meeting to approve those minutes just because the title of the meeting is the same, right? It's the nature of the meeting or the type of meeting that matters the most. I will point out no quorum is required for a budget ratification meeting. So you don't even have to have a motion to approve the budget. The default under the statute is that even if there is no quorum, even if there is no motion, the budget is ratified. The only way that the outcome is different is that if more than 50% of the total voting power in the community votes to reject the budget. And so what that would require is the attendance in person or by proxy of more than 50% of the voting power in the community, a motion to reject the budget, a second of that motion, and then the vote of more than 50% of the voting power in the community to reject the budget. Unless all those things happen, the budget's going to be automatically ratified, and that's true whether there's a quorum or not. I think that covers it, but Lisa, if you wanted to add anything, let me know.
Nope, I'll just go on to the next question. The next question is, what law changes, if any, will be coming up in regards to audits? Can you please clarify the current laws regarding audits in terms of when an association is required unless a vote by a specific percentage? So this is what I was referring to before we were talking about audits. The biggest change is that when WUCIOA for all is in place in 2028, that all communities will be subject to the WUCIOA provision about audits. And that provision says that in the case that all communities need to audit their community with annual assessments of $50,000 or more. In the case of an association with annual assessments of less than $50,000, an annual audit is also required, but can be waived annually. Keep that in mind, annually by unit owners other than the declarant of units to which a majority of the votes in the association are allocated, excluding the votes allocated to units owned by the declarant. So basically, a majority of owners need to vote or need to vote to waive the audit requirement. That's under WUCIOA, and that will be what is coming into play for everyone in 2028. You asked about the other statutes that are currently in place. We talked about that before. Under 6434, it's a condominium association with fewer than 50 units can vote to waive. And under 6438, which is the HOA Act, if you have an association with annual assessments of $50,000 or more, similar to the WUCIOA, need to be audited, but the audit may be waived if 67% of the votes cast by owners in person or by proxy at a meeting of the association in which a quorum is present vote again annually to waive the audit. So the numbers are just slightly higher under the HOA Act to waive the audit requirement. But the short answer to your question is everyone's going to be subject to the WUCIOA rules in a couple of years. So keep that in mind. But for now, there are slight variations within the number of votes needed and the size of community provisions. Anything you want to add to that, Valerie?
The one thing I'll add is that vote has to be taken annually. It's not a once and done thing. You have to have an ownership-wide vote every year in order to make a valid decision to waive the audit that we can then defend in court if that's ever called into question. So that's something to keep in mind. Our next question is this. We have an owner who hired a person to do work for them inside of their unit. The unit owner's employee injured themselves while accessing the unit. My question is, why are all the owners liable for the insurance claim against the association when we didn't hire the person or know that they were even being hired for the benefit of one owner only? I'm going to start by saying that this is way too specific. So I hesitated whether to even include this question. And I really want to tell you that if this is a question that you're dealing with in your community, you need to discuss it with your association attorney, because it's going to require an analysis of both your governing documents and the available insurance that the association has. But the general rule here is that a landowner, like the association, is responsible for the property they control. And an association could be liable for any person that's injured in the common areas. So the fact that the injured person might be an employee or a guest, tenant, visitor, contractor, whatever, of an owner is irrelevant. People who live within your community have the right to hire somebody to come into their unit to fix their dishwasher, or to hire somebody to come in and paint their bedroom, just like you have the right to hire somebody to come in and babysit your child, or to come in and reupholster your dining room chair. I mean, like, you name it. You live there. That's your home, and you have the right to invite people who don't live in the community to come have dinner in your unit, to perform services for you within your unit, etc. And the fact that the injured person might be an invitee of one kind or another of an individual unit owner is irrelevant to the association's obligation to maintain the property in a safe condition. So this is exactly why an association procures general liability insurance, which is to help protect the association from, slip and falls are like the most common example of these types of claims. But related claims as well. So that's about as much, I think, as we can comment on that topic. And if you have anything to add, Lisa, please feel free.
No, I don't think so. I'll just go on to the next question. I think we have a few minutes left. Is a board composed of less than the full number of allowed or required numbers valid? Are their decisions valid? The short answer to this question is probably they are, yeah. Look at your governing documents again. When I beat that drum, what is the number required? What are the number of officers? And what is a quorum for your board meeting? But most of the statutes require only that there be at least 3 members on the board. So despite what your governing documents may say, if you've got 3 members, if you're required to have 7 and you've got 3, you're probably in good shape as long as any decisions made by the board were at a meeting in which a quorum of the board members were there. I think anecdotally, both Valerie and I could say that a lot of our communities are running with a less than full board and are running just fine. You may, if your board is concerned, look again at your governing documents and see how can we appoint new board members to fill vacant spots if that is a concern. If you're having people absent and not able to make quorum at meetings, or just want to have the number that's allowed by your declaration, look and see how you can appoint them to fill terms. That is certainly a great option. We all know that is sometimes easier said than done to get folks willing to serve on a board, but that if you have people who didn't sit for the last election and want to serve, then great. Follow the steps to get them appointed. But the short answer, if there's a quorum at your meetings, records were kept as required, meeting minutes reflect the actions of the board. I think any decisions that board makes and any actions they take are probably valid. But if you have real specific questions about things, if you're concerned about any of those steps, for sure talk to your legal counsel about those questions. Anything you want to add, Valerie, in the next couple minutes?
Yeah, I mean, I guess the only thing I would say is if there's a difference, I think, between a board operating with less than the full number of board members because folks have resigned and they just haven't been able to get volunteers to be appointed or to run for those open positions, and a board actively sort of refusing to seat additional board members that are required by the governing documents. I don't want to assume which is the case for this community. And if you think that the board is acting improperly, that would be a signal that you should consult with an association attorney that represents individual owners to advise them on situations just like this. I think that we are out of time. We do have a few other questions in the chat, and unfortunately, we're not going to have time to get to them. So we'll add them to our list for 2 weeks from now, because remember, we're not here next week. But thank you all so much for joining us, and we will see you in a couple of weeks. Bye, everybody.